Counsel, these proceedings are being video and audio recorded, so we ask you to please identify yourselves and your clients at the beginning of your arguments. Each of you will have 20 minutes. Appellant's counsel, if you watch the clock and reserve as much time as you desire for rebuttal. And also, please keep in mind we've read the briefs. We've discussed them in conference, so we're familiar with the basic procedure and facts of the case. With that, counsel for appellant, you may proceed.
Thank you, judges. E.J. Kodalek, appearing on behalf of Joseph Dominguez. Mr. Ridge Hicks is also, my co-counsel, is also present this morning. I'd like to reserve 5 minutes of time for rebuttal. Judges, this is a case, even though the abuse of discretion standard applies, it's a case where you have the option to look over the trial court's shoulder and make an independent determination concerning whether relief under Rule 60C should be granted. And the reason for that is because under the Chapey and Davis cases that we've cited, the material facts that warrant relief are essentially undisputed. So all that needs to be done in this case is look at those undisputed facts and apply the principles under Rule 60C that we've talked about. And in our view, that should allow you to conclude that there was an abuse of discretion in the case. So there's two independent reasons, as laid out in the briefs, under Rule 60C why relief is warranted here. The first one that we've talked about is the excusable neglect under Rule 60C1. There are three requirements for that relief. Two of them are undisputed. The prompt notice or the prompt seeking of relief requirement and the meritorious claim requirement. The only one that's really in dispute here is whether or not there has been mistake, inadvertence, or an excusable neglect. And the basis for that is, in this case, is the principles outlined in the Addison case. The Addison case and the Gerstenberger case both talk about if counsel has a established procedure that he was utilizing, an established office procedure designed to ensure timely response, but was deflected from his purpose by an interruption, that is sufficient to be considered excusable neglect under well-established Arizona case law. And the affidavit of Mr. Hicks establishes that very important practical predicate. The affidavit is not disputed in the record. The fact he had such a procedure is undisputed. The fact that he was deflected from his purpose was undisputed. So I would submit under those undisputed facts established in the affidavit, applying the Addison case, you have excusable neglect in this case, and that's a basis for granting relief. Now, what the appellee is trying to do is throw up a smokescreen here. They're trying to argue that, well, look at all these things that Mr. Hicks did not do. He didn't properly and timely serve the defendants in the case. He didn't conduct discovery in a diligent manner. The key point to understand there is that has nothing to do, those circumstances have nothing to do with the principle in Addison. You have a deflection here, you have an interruption that's undisputed. And Addison says when that results in a calendaring error or another mistake on the part of counsel, that is excusable neglect. The second thing that's important...
Counsel, what if you have two calendaring errors? Is that second calendaring error relevant to the analysis?
The calendaring error, a second mistake is only relevant to the analysis if that mistake contributes to the dismissal of the case, causes the dismissal of the case.
But doesn't it also tell us whether or not a law firm has, I think your words were, a calendaring system or an effective calendaring system?
It may shed light on that depending on the nature of the mistake, but this was not a case where you have two calendaring errors. I know they're trying to argue that, and we addressed this in our reply brief. The first error that was talked about was a mistake in terms of notifying Mr. Hicks as to when he needed to contact defense counsel to get their answer filed properly. That's not a calendaring mistake in terms of calendaring an order of dismissal. There's only one calendaring mistake here that led to the dismissal of this case.
But was it a calendaring misstep?
not in terms of what's normally calendared in an office. What law offices normally calendar are deadlines imposed by the court, discovery deadlines, deadlines imposed by orders. This was just more of a tickler, I think it's fair to say. And by the way, Mr. Hicks specifically mentioned this in the second motion for extension of time. Admitted that, look, I should have put a tickler into my system to contact defense counsel to get this thing moving. He didn't do that. And he admitted that to the judge. The judge granted that second motion of extension, notwithstanding that. But that type of tickler is not something that goes on a lawyer's calendaring system because it's not a court-imposed deadline or order. So if this were truly a calendaring error with respect to court-imposed deadlines or orders or discovery deadlines or things like that, Judge, I would say that you have a valid point. And I do think that it's relevant if you have multiple calendaring mistakes. I think that's relevant to whether the office procedure is adequate or not.
So what, if you could clarify for me, what is really the difference between tickling an event in a calendar and calendaring an event?
The calendaring of the event has to do with what is normally calendared in an office when orders come in, which have specific court order deadlines, when pleadings or other documents come in that have specific deadlines imposed by the rules. What we were talking
put on
about,
the calendar to give an alert to the attorney or staff.
That's correct.
And what's tickling an event?
A tickler in this context is when you want to be reminded of something, for example, in this case, contacting opposing counsel to get them to do something that they should be doing.
And is that something that it was plaintiff's counsel's responsibility to do?
That's something that plaintiff's counsel wanted to do in this case. It was not something that would go on their calendaring system because it was not a court-imposed order.
Well, is that something that he had to do, whether it was by court order or not? Is that something that he was required to do in this case?
That's something that he was not required to do. It was something that it would be better if he did it because what he wanted to do was notify opposing counsel that they had to get their answer filed.
Well, and then he had to do it at some point. It wasn't going to happen by magic.
Yeah, but it was not something that was court-imposed, and it was something that the...
He imposed it on himself by granting them an open extension.
True. But it was something that was more or less discretionary. He didn't have to grant the open extension, and moreover, this was something that was not ordered by a court.
Right, but he didn't have to grant the open extension, but once he did, didn't he have to give notice subsequent in terms of when the response would be due?
Judge Cruz, I am not going to dispute the fact that it would have been better if he would have done that. I think the issue is this is not something that would normally go into his calendaring system because it was not a type of order or deadline that I've described to you before. I think the second point that can't be overlooked here is that failure had nothing to do with the dismissal of this case. What caused the dismissal of this case, and I would urge the court to look at the City of Phoenix Geiler case because Geiler talks about other mistakes, other things that counsel could have done to prevent something from happening. And what Geiler, the message from the Supreme Court's decision in Geiler is, unless these other factors caused the actual dismissal of the case, those factors are not relevant. The focus is a microanalysis, particularly in this case. The focus is a microanalysis on what caused the dismissal. And what caused the dismissal here was a simple calendaring error. And under the decision of this court, particularly in the Maldonado case, calendaring errors are excusable. They're the type of errors that ordinary lawyers make, and they're not grossly negligent.
Go ahead.
No, that's all right.
Doesn't Gorman tell us that a record establishing ongoing active prosecution of the case is a critical factor? It's something that we need to look at, not just these discrete failures, but a record of the prosecution of the case?
Certainly in the Gorman case. Gorman, by the way, was a Rule 60C6 case. The topic we're talking about now is Rule 60C1, which is excusable neglect. But to directly answer your question, one of the factors in Gorman is were the parties vigorously prosecuting the case. Man, I can talk about this in more detail if I get to Rule 60C6.
Please
but,
do, counsel.
I'm sorry?
Yeah,
Please do.
let's go ahead with C6.
I will do
Yeah,
that.
yeah.
Because I think you start with Rule 60C6, the basic analysis in the Jepson versus New case, because 60B6 I think is critical here. If you don't buy the excusable neglect analysis, 60B6 and Gorman lays out a roadmap where if these circumstances exist, you got to grant relief. It's appropriate to grant relief. And I'll begin with the observation in the Jepson case, which says dismissal of a case in the midst of active prosecution of the case doesn't advance the interests of justice. In fact, it's contrary to the interests of justice. And again, to answer your question, Judge Cruz, yes, active prosecution is important. But the key fact here is, when was that active prosecution occurring? If you look at both Gorman and the Jepson versus New case, in both those cases, nothing had been done for over a year at the beginning of the case. That's precisely the facts of our case. Nothing had been done for a long period of time. Nonetheless, the Supreme Court in both Gorman and Jepson took the position that you can still grant relief under those circumstances. Why? Because at the time of the dismissal, on or about the time of the dismissal, there was active prosecution of the case.
Counsel, let's explore that. Active, what active means. It's unclear to me in the record. It seems that we have conflicting positions whether or not your client responded to the non-uniform interrogatories. So my questions are, number one, is it in the record? Two, where? I guess first, what's the answer? Did your client respond to the interrogatories or not?
Well, there were responses to I believe it was the request for admissions. There may not have been responses to all the discovery, but that's just...
The interrogatories, counsel, were they responded to?
I believe they were. And
where in the record is that?
APP, my appendix, 82 to 88 and 91 to 99. On August 17, 2016, Dominguez served his responses for requests for admissions and non-uniform interrogatories, along with Dominguez's initial Rule 26.1 disclosure statement.
Okay.
82 to 88, 91 to 99.
Did Dominguez tender any affirmative offensive discovery?
Of a type permitted by the rules, I believe the answer to that is no. But again, what the focus here, Judge, has to be on the standards set forth in the Jepson case. The Jepson case says you've got to look at the activities of all the parties, not just the plaintiff. And I appreciate your focus on the plaintiff. But things were done by the plaintiff in this case, submitting a Rule 26.1 initial disclosure statement, for example. That is a fundamental part of a party's prosecution of a case. And that was done in this case. Mr. Dominguez showed up for his deposition. He actually showed up for his deposition after the dismissal date in this case, because there was an agreement by counsel to cancel it. He never got the word on that. Is that the conduct of a party who is abandoning a case? If he shows up for a deposition after the deadline has already passed?
There were no dispositive motions exchanged, right?
Correct. That's correct. So,
Unlike Gorman, there were competing motions for summary, or there was at least one pending motion for summary judgment pending before the court at that time in Gorman.
and there are factual differences between this case and Gorman, but I would
Are we
submit-
going to have that problem in every single 60C6 or 60C1 case?
Well,
We're
I
going to
think
have
you've got-
factual differences.
Well, of course, and that's why this is a case-by-case inquiry. And that's why it's so important for a trial judge to look carefully at the facts of the case. Gorman says that.
How do we know he didn't?
Well, we don't know what the judge did because there was no minute entry indicating.
That's often the case. We presume that trial judges know and follow the law. We say that all the time. don't we?
And Judge Brown, I'm aware of that case law. What I'm asking you to do is look at the Davis versus Davis case that I cited. And Davis versus Davis says, in a situation where the trial judge, in an abuse of discretion situation, the trial judge does not indicate the reasons for his or her decision, you can still reverse based on the undisputed facts of the case if relief is warranted. And that's the situation here. So I appreciate the fact that this is a difficult problem for you when a judge does not have any kind of exposition of his or her opinions. But look at what we're dealing in this case is a meritorious claim by somebody who's severely injured, whose case is thrown out essentially because of a procedural error. And that procedural error is an error, and this is critical, and something that I would expect counsel to address when they get up here before you. Rule 16, under Rule 16b, the responsibility to file a joint pretrial statement is a joint responsibility under Rule 16b. Yet you have lawyers sitting back, the defense counsel in this case, and by the way, I'm not saying this to immunize Mr. Hicks's responsibility here. I'm just pointing out the reality of the situation. You've got lawyers, both sets of counsel, who have an obligation to file a 16b report and scheduling order, and it wasn't done here. And it wasn't done in a situation where presumably, and I don't know this for a fact, but presumably opposing counsel knew about this deadline, knew that it had passed, was participating in discovery after the deadline was passed, and never brought the issue up. Why should defense counsel not be faulted here for also not complying with their obligations under Rule 16b? The only party who's being penalized here is Mr. Dominguez. Mr. Dominguez can't bring a claim, a meritorious claim, because both sets of lawyers in this case didn't do what they were supposed to do under Rule 16b. Yet his case is being thrown out.
Did you want to reserve?
Yes, I did. Thank you.
Good morning, Your Honors. My name is Vanessa Bragg, and I'm here on behalf of the appellees. And with me is Jaron Giesler. I'm my associate, as well as Katie Stewart. I suppose the first thing I would like to deal with is jurisdiction, which we had filed a motion to dismiss on yesterday. It's a critical issue here because the court has an independent duty to assess jurisdiction under ARS 12-2101A, as well as Sorensen versus Farmers. There is no jurisdiction here, and the reason is discussed at length in our motion to dismiss, which was filed, but even if it had not been discussed in our motion to dismiss yesterday, it would still be an independent obligation of the court to take a look at it. And the reason is that judgment was entered, final judgment was entered December 21st, 2016, and that began the period on which to calculate the 30 days under Fields v. Oates.
Wasn't it your position in the Superior Court that that was not a final judgment?
No, Judge. Actually, what we filed was a notice of errata, noting that we mistakenly cited B, 54B instead of 54C.
Well, it's more than that. You said there's no just reason for delay, which is the classic 54B language. It wasn't just one letter, was it?
Oh, no, we actually did change the word a little bit.
Exactly, you changed it substantially.
Well, I believe if you do a comparison, Judge, and you take a look at it, what you'll see is that we actually put the no just reason for delay for entering final judgment.
So how could we be assured, just to cut to the chase, how could we be assured that appellants weren't relying on the fact that you filed a notice of errata and then decided not to file a notice of appeal until the judge corrected the mistake? Because without 54C, it wasn't appealable.
Well, Judge, the reason why, so you could accept the notice of errata potentially as being a Rule 60A motion. But under Rule 9E1E of the Court of Appeals, the only time a Rule 60 motion under the Arizona Rules of Civil Procedure can extend the time for filing the notice of appeal is within 15 days. You'll see that the notice of errata was filed within 20 days. And so regardless, that particular judgment, which plaintiffs knew very well was a final judgment because it did, in fact, dispose of all claims as well as all parties, Judge. And so you'll see that because the Rule 60, if you consider the notice of errata a Rule 60A motion, because 15 days had already passed.
How was it possibly a 60A motion?
Well, no,
That?
no, we did not call it that, Judge, but if you were,
We're probably getting far afield here
Yeah,
because
Counsel.
they haven't had a chance to respond to your motion that received at 4 o'clock yesterday afternoon, so we probably should just move on to the merits at this point.
okay, thank you, Judge. So moving forward to the merits of the case, obviously, we've talked at length in our briefing as well as the opposing counsel's briefing regarding the discretionary issues. Plaintiff cites to Addison Cienega, which he actually discussed at length during his argument, but this court actually distinguished Addison in the case of Ashby versus Bigelow. Coincidentally, Ashby was also a Judge Udall decision from the Maricopa County Superior Court regarding 60C. In fact, the minute entry dated September 15th, 2015 by Judge Udall actually reflects that the motion was simply denied, which is one of the arguments under Jepson, was that because there's no, plaintiff is saying, or appellant is saying, because there's no explanation within the denial, then somehow you have to or should perform some sort of deeper analysis. But if you take a look at the Ashby, it was actually written by Judge Paul McBurdy, and it was delivered decision of the court, presiding Judge Kenton Jones and Patricia K. Norris joined, and in that particular case, it was an untimely appeal from arbitration. There was a request for both 60C relief as well as 6B relief, time for extending a notice of appeal from the arbitration, and Judge Udall denied that particular motion. This
Counsel?
court, yes.
How is this case different from Gorman?
This case is substantially different than Gorman, Judge, actually, and I put together a timeline of Gorman, and I know the court is familiar with Gorman as well. And so when you look at actively prosecuted as required by Rule 60C, not only I believe the words vigorously and diligently prosecuted. And if you look at Gorman, Judge, I could even hand this to you if it was easier. There was motions for summary judgment pending. There was a motion to compel pending. The parties were actually exchanging discovery. In this particular case, what you'll find out, and you had asked this, there were no responses to non-uniform interrogatories and uniform interrogatories. What counsel was referring to in the record was the request for admission and non-uniform interrogatory. And the reason is that particular document, which you'll see on the record, I believe it is APP 82 is where it begins. There was requests for admissions, and then the very last page includes one interrogatory that says, if you did not admit, let me read it in the record.
So, counsel, there were non-uniform interrogatories that had been tendered by your client that had not been answered when this case was dismissed. Is that accurate?
That is accurate,
and
Judge.
had the clock run on that, what is it, 60 days? Had the clock run on that?
Yes, Judge. In fact, the clock had run. I specifically calculated it because at that time, the rule was 40 days. It's now 30 days. However, sorry, let me pull that up for you. So the non-uniform interrogatories were sent on, I apologize.
And was there any agreement to extend that deadline?
No, there was not, Judge. And what you're going to see was one of the questions we had was this argument that there was a mutual extension of deadlines. Mutual means both people have to be getting something from it, I would assume. Discovery was never propounded on us. What you're also going to find out, so 40 days had long since passed. We actually served July 1, 2016, non-uniform interrogatories and uniform interrogatories pursuant to Rule 33. We also served a Rule 34 request for production. So within 40 days, Judge, I believe 40 days on top of July 1 would have put you at the beginning of August. August 9 would have been 40 days.
So let's explore that. The word, I think, diligence is the mark, right? That's what the case says.
Yes,
right?
Judge.
Right. What here didn't happen, or what needed to happen to qualify for Gorman? Why are we Gorman deficient here? What process, what procedure, what's missing?
Okay, so diligently, the plain meaning of the word, in a way that shows care and consciousness in one's work of others. And the difference is where we don't have a Gorman case here, we have numerous calendaring errors, and I disagree with plaintiff's counsel that Geiler or Jepson indicate that they're you just look at this one error. Because if that was the case, why would we have a diligently and vigorously prosecuted the case standard? It would be case specific. So I want to go through the errors with you really quick. Error number 1, the second request for extension acknowledges that he had made a calendaring error, essentially, and whether or not you want to parse words and call it a tickler or a calendar, it's the same thing. It's a reminder of something to do. It's a deadline that you need to do. Error number 2, although plaintiff says they showed up, Mr. Dominguez showed up for the deposition, you'll see in the record in the emails, plaintiff's counsel didn't show up. It had been canceled, and plaintiff's counsel failed, or the assistant, to tell their own client that the deposition had been canceled. So the record will show, if you look at the appendix on the emails, that Mr. Dominguez actually showed up to his deposition without counsel, and our office had to explain to him that it had been canceled. Granted, opposing counsel was he was very kind and appreciative that we had advised his client that it had been canceled, but that is yet another error. Error number 3, we discussed the non-uniform interrogatories and uniform interrogatories, significantly past due, even after reminders. Errors number 4, the request for production, and although they claim that they sent although they claim that they sent releases, they didn't. What you'll see in the record, if you actually review the emails back and forth, all they did was send a copy of a release that allowed to disclose CMS records. They never provided signed release. CMS is Medicare. They never provided signed releases for the individual providers. So that's not the case. Error number 5, and that was despite, you'll see the emails, numerous reminders, hey, we still haven't gotten these authorizations. Error number 5, I just mentioned the authorization. That was in addition to the request for production as number 4. And error number 6, and although you don't want to hear, I would say the notice of appeal was untimely filed. But that's why we believe that this case doesn't evidence a one mistake.
Counsel,
sure.
Let's talk about litigation. What could have happened in this case that didn't, to indicate that your colleague doesn't qualify for Gorman as prosecuting vigorously? What needed to happen that didn't at this point in the case?
Offering discovery responses could have happened. We sent them out immediately. We were diligently defending and vigorously defending the case. We sent numerous follow-up reminders. There was no response despite asking for them. In fact, the reason the deposition was canceled was because we hadn't yet got his response to interrogatories and his response to, both uniform and non-uniform and request for production. We hadn't gotten anything. In fact, we didn't even know if there was a workers' comp.
That would be your bright line rule. If there's exchange of discovery, then that would qualify as vigorous prosecution.
I would say not just exchange, but also answering. You can't just send something and then sit on it. Yeah. So
okay,
if he had responded to discovery, that would be some evidence of a diligent and vigorous prosecution of a case. I do want to address quickly this idea that Rule 16 is a joint obligation, because I completely agree. And Mr.
So,
Kotelek,
counsel, that's it. You just had one.
Oh, I'm sorry.
Which was
no.
exchange of discovery. That would have qualified. So if your colleague had answered those interrogatories, you would concede that Gorman provides relief.
No, Judge. I don't think it would be just that. I can come up with several other reasons. They could have propounded discovery on us. They could have set the deposition or sought to set the deposition of National SHOTCRETE representative or the person that they alleged was negligence. Any number of things.
Request for a Rule 16 conference. Is that good enough?
No, I don't believe a mere request for a Rule 16 conference is going to be enough. But, however, if he had done so before the deadline, I suspect that the trial court, in its discretion, which is given wide discretion under Rule 38, would not have dismissed the case. So it's just another piece of the puzzle evidencing a habit of errors, if you will. And by no means is any lawyer, including myself, perfect. But there comes a point where excusable neglect or mistake is no longer excusable. There comes a point where your calendaring system does not work. And we have a system and numerous issues here that are evidencing something was not working.
Counsel, did you or will you concede that you entered into an agreement with your colleague that set a deadline beyond what was the dismissal date under the inactive calendar.
Yes, and I can tell you why, Judge. If you look at when the order was entered pursuant to the ex parte motion, the second one, it was entered before we ever appeared in the case. It was entered 2 weeks before we filed an answer. We had no idea at that point in time that it had been set by the court. It was never relayed to us that that was set by the court either. There's no case that indicates that we have an obligation to go find all the prior filings. So the only reason that that had been agreed to say, fine, you know, okay, and by the way, it wasn't agreeing, it wasn't, he wasn't affirmatively asking for extensions. If you look at the emails, it was us saying, where are these? Oh, I'll get them to you as soon as possible. I'll get them to you soon. That was the issue. So with respect to this lying in wait argument or the vulture argument, that is not the case here whatsoever. At the very least, a diligent attorney would provide opposing counsel with ex parte motion and a copy of the order that he had and a date that was set at his request. It was his request to do 60 days. It's not like he asked for 120 and then the court only shortened it to 60 days. So from a calendaring perspective, okay, fine, I received the signed order and I forgot to calendar it, but when you are the one suggesting the deadline, that's almost what you could consider another calendaring error, because why would one suggest a deadline, know the order got granted, but then not calendar it, or only calendar it after the court approves it?
So what was, there was one agreement? Is that accurate? Or, I mean, because it's not clear. The record sometimes talks about plural agreements.
I can go through the timeline with you, Judge.
Well, do you recall? I don't want to take your time, but
no, that's okay. The timeliness and the emails going back and forth. On June 13th, 2016, we notified opposing counsel that we were retained to defend and to send over any medical documentation that he has as soon as possible, as well as the workers' compensation lien assignment, given that this case was filed a mere week before the statute of limitations ran, and under the statute would therefore mean that there had to be a work comp assignment. That's what we wanted to know. We still don't have a copy of that. We never received a copy of that. On June 13, 2016, we sent a Rule 55. On June 14, 2016, the opposing counsel said he would get all the information he has and that he was leaving on a vacation for 8 days, but that he would take his attention to it then. On June 30th, and mind you, that June 14th, I believe, is the day that the order was entered. June 15th was the day that the second dismissal deadline extension granted was given, and the new dismissal deadline gave the 60 days.
Counsel, agreements.
Okay, I'll go back to the agreements.
Arrive, and I don't need dates. I don't need dates.
Well, based on our review of the emails that went back and forth, there was no agreement. There was no, okay, I will grant you yet another extension. There was a, where is this information, and saying, I will get it to you. And of course, at that point in time, we didn't say, no, you can't get it to us anymore. We were diligently trying to obtain that information. And I believe the record, if you take a look at all the emails that were attached, in fact, attached to the request for relief, by the way, in front of Judge Udall. These were not provided for the record for the first time here. So Judge Udall had all of this information to take a look at when he was deciding on the motion, the Rule 60 motion that had been filed.
Counsel, you didn't know what the inactive calendar deadline was, though, right?
That is true.
Okay. How is that? Is it relevant? Is that relevant?
No, it's not relevant. And actually, Judge, we looked for cases trying to find whether or not us not being provided the prior pleadings and orders was somehow whether we had a duty to affirmatively go find that information. And there is no case that indicates that. In fact, it would be plaintiff's obligation under the order to ensure that it was done by that specific time. And that was the trial court's order specifically entered at the request. And the order was also drafted by the opposing counsel. And so this wasn't like a minute entry, it's a drafted order. And I would say, no, it's not relevant that we didn't know. And I suspect your next question will be, well, Ms. Bragg, what is the prejudice? What is the prejudice if you didn't know about the deadline? And I would cite to Passmore versus McCarver, which is a recent case by this court in 2017, and they looked at prejudice. And one of the things that they looked at was extreme and unjustified delay. Specifically, it said it was within the trial court's discretion to find that prejudice caused to plaintiffs by denying relief was outweighed by the prejudice defendants would suffer if the claim moved forward in light of the extreme and unjustified delay. And while opposing counsel doesn't believe that the history of the delay and the mistakes is relevant to this inquiry, I would suggest to you, if you read the case law, it absolutely is.
Would you call it extreme delay?
I would call it extreme delay, yes.
How long are we talking?
So the complaint, I'm going to say I'm going to just give you a brief timeline really quick.
Can you just tell me how long the case delayed?
The accident was April 30th, 2013. We still have 0 medical records. We never received any. We never received a work. I don't even know as I stand here today, we've never seen the work comp assignment from what I recall. So I don't even know if this is a viable.
So it happened in 2013, 2015.
Yes, 8 days before the statute of limitations ran, the suit was filed.
And dismissed?
And notice of intent to dismiss, 7/25/15. Complaint was not served
The
until.
actual dismissal, though.
I'm sorry?
The actual dismissal.
Oh, I'm sorry, September 2016.
So from 2015 to 2016.
Nothing happened, other than we answered on June 30th and served discovery, which was never responded to, other than the
Believe that
request
to
for
be
admissions.
extreme delay?
I believe that's an extreme delay, yes.
Is your position that Mr. Dominguez will not be substantially prejudiced if the dismissal is upheld?
I believe that if the dismissal is upheld, he will be prejudiced, but I don't believe it outweighs the prejudice to the defense, because it's not just extreme, but it's also unjustified delay. And there is no reason for the delay that had continued from the outset of this particular case. And so from a rule, because now we're looking obviously at the, Rule 60C6, and I think if you take a look at the cases that have analyzed Rule 60C6, you'll see that most of them, even the ones cited to by opposing counsel, the trial court's discretionary calls were upheld. Because there's a reason why we grant wide discretion, particularly under 60C6, because it's a catch-all. It literally is a catch-all. So every single mistake or dismissal is somehow going to be prejudicial. And there comes a point where we allow the trial court to make that decision based on the record before them. And the court here, probably on its own, found extreme and unjustified delay. I can't imagine that Judge Udall, after granting...
Counsel,
I apologize.
I have to cut you off.
Thank you so much.
Thank you for your argument.
Thank you.
Thank you.
So, counsel, picking up where we left off with FLE's counsel, how does this circumstance fall outside of what's covered under Rule 60C 1 through 5? How does this not fall within 1 specifically, such that you can proceed under 6, the catch-all?
Well, what I'm arguing, Judge Cruz, is if you find that there is no excusable neglect, then under the Gorman case and the Jepson case, you have the option of finding that the relief is warranted under Rules 60C6.
But how so? Because we can find that it does, the analysis falls under 60C1. However, the Superior Court should be affirmed, and therefore we can't get to 6 because the analysis falls squarely within 1.
If there's no excusable neglect, then my point would be then the analysis does not fall within 1 because you're not finding excusable neglect. The Gorman case makes it clear that you don't need to show excusable neglect under Rule 60C6. You can take that into account because everybody makes mistakes, but that's not an element. So you have the option of finding under one or the other depending on how you deal with the Rule 60C1 issue. I don't think it's an exclusive decision on your part. And let me focus on a couple of things real quickly. Judge, I know you don't want to hear about the jurisdictional issue, but I feel compelled to at least comment about it. and we'll provide, don't worry, we'll provide a written response. But I think you nailed it. Rule 54C says there's no final judgment unless, in a case like this, unless the magic Rule 54C language is there. It's very explicit. There was no Rule 54C language in the first judgment. There was in the second. There is no final judgment unless Rule 54C is complied with. It's that simple. Let me get to Rule 60C6.
Okay, can you clarify? Responses to interrogatories. Counsel said admissions, yes. Responses to interrogatories, no.
There was that one response to the interrogatories. Judge, I'm not going to tell you that all the discovery in this case was timely responded to, but this was a mutual problem. And I think here's the key point, and the answer to your question. If you look at the record, our appendix, which is APP 36, please look at the emails on that page, APP 36 and then APP 37. These emails established that there was a mutual extension of discovery deadlines, not only for National SHOTCRETE, because they wanted an extension to file their disclosure statement, which is a key. Anybody who's done civil litigation knows the filing of a disclosure statement is the key starting point for litigation. And National SHOTCRETE hadn't even filed their disclosure statement as of September 20th. That was 2 weeks after the case was supposed to be dismissed. So they asked for an extension to file their disclosure, the Rule 60 26.1 disclosure statement. And here's what the email on September 20th says. It's, again, APP 36. This is an email to Mr. Hicks from National SHOTCRETE's counsel. Thank you for the update. Our initial disclosure statement was completed yesterday and mailed thereafter. Our extension was mutual, and I appreciate your offer to provide discovery responses and the medical authorizations as soon as possible. We will look for the authorizations response after your client meeting. And this is in response to a lengthy email from Mr. Hicks where he describes what happened in connection with the deposition and describes what was being done at that particular time. Again, Your Honors, this is after the supposed dismissal date in the case. Counsel are proceeding as if this case was being actively litigated and was ongoing.
Counsel, was it relevant that your client did not answer the non-uniform interrogatories within the required date?
No, I think it's of interest to the court, but it is not dispositive or controlling for this reason. On page 15 of my reply memorandum, I cited language from the Jepson versus New Supreme Court decision. The Supreme Court in Jepson versus New says a number of things that are very relevant to your decision today. One of which is, and this is directly contrary to the rule that counsel is trying to persuade you to adopt, you don't need formal discovery in order for a case to be actively litigated. What the Jepson versus New case says is, additionally, discovery need not be formal to evince vigorous prosecution. That's the Supreme Court. It's directly contrary to what they're telling you. As in Jepson, this is the Supreme Court again, as in Jepson, where authorizations are provided for the release of medical information, discovery may be conducted by informal means. Well, by the way, that was exactly what was going on here. The record establishes that the parties were exchanging medical authorizations, trying to get medical records. My client and Mr. Hicks sent over medical authorizations. This was being done after the supposed dismissal date in the case. Let me point something out.
Counsel, I'm going to have to I'll let you go on a little bit longer.
All right.
I'll have to cut you off.
Thank you.
Thank you for your arguments, both of you, in this very interesting case. The court will take it under advisement and issue a decision in due course. We'll stand adjourned for a few minutes to prepare the courtroom for the next argument.